That is a enormous hurdle. If you're the defense, she ends up dead and you've got a burn cage, chainsaws, and parts that are dismembered.
Right.
You better have an explanation for what went on.
Mark, there is something so weird, for me at least, in what happened with David this week, where prosecutors laid out in gruesome detail pretty much their case. And it's puzzling to me, but I do think there's something behind this. I have never before heard of anything like a prosecutor's preliminary hearing brief where they lay out what they're going to do at the preliminary hearing, because they don't need to do that. They just do it at the preliminary hearing. I've never heard of a brief before. A, am I right? And B, if I am right, what's behind this?
So I just talked to somebody and I said, conservatively, I've probably done 10,000 cases and thousands in the criminal courts building. And I think I've only seen less than 10 preliminary hearing briefs, and almost all that I remember were in fraud cases where there were voluminous documents in which they had to kind of summarize, if you will, because they weren't going to put on a summary witness. It's astonishing to me that they filed this. It's astonishing to me that they have handled it this way. And one of the reasons I like you as a podcast partner is you issue spotted that, and I don't know anybody else who has.
Well, what's behind it? That's what I do have an opinion about what's behind it.
Why don't you give me that opinion? Because I don't want to, I'm not going to lead you into where I am on this.
I mean, I don't know how to say this where it doesn't sound harsh, but it kind of felt like a press release to me.
Yeah, it's exactly what it was. And it was a way to push back on everything that has happened and to slime the jury pool and obviously him. I mean, when you say once, twice, three times child porn, and then you say wiretaps, and then you have 3 grand juries, and then you file a preliminary hearing brief, people have to understand, as you said, it's virtually unheard of. And I think they are, by the way, and they push back on you hard, I'm going to guess, when I said there was an all hands on deck once he was arrested.
They said that was a lie. They said that was a lie.
Huh? Yeah, exactly. And the preliminary hearing brief is they do it all the time, if you believe that.
Yeah, I mean, they didn't say that to us. They do it all the time. It's just I'd never seen it. So, look.
I've never seen a preliminary hearing brief. I've never seen, not once but twice, go to a superior court judge to muzzle the medical examiner. I have never seen a 8-month investigation into a murder where they then, the investigating agency arrests the person on a Thursday so that it'll sit there until a Monday. I've never seen a defense in response to that say, we're not waiving time on a special circumstance murder case, and we're ready for a preliminary hearing to force the DA's hand, basically. And that's exactly what happened. And the DA, to their credit, they responded. They didn't run to the grand jury. They said, no, we're ready to go.
Right.
And basically called bluff, called the game of litigation chicken was won in this case by the DA, who slimed him with that brief. Which, did you read the brief carefully?
Oh, yeah.
Oh, yeah. And did you have a takeaway from that?
Yeah, I do have a takeaway from it. And we should just say that this brief, when you read it, guilty if you take it at face value. I mean, Correct. The guy lures her, Celeste Rivas, to his house, after she threatens to expose their relationship and ruin his career when he's got an album coming out 3 days later. And then an hour after she shows up, he makes this mysterious drive to Santa Barbara He orders a shovel from Home Depot. He orders chainsaws from Amazon, body bags, heavy-duty garbage bags, laundry bags, a blue inflatable pool, and
Let's not forget the
they
bird
find
cage.
pieces of the pool in her body. There is a finger that they never found, which was presumably cut off, which has a tattoo that matches one of his tattoos, and on and on and on. So here's my takeaway, that when you read it, he's simply guilty. Yeah, it's still circumstantial because, the one weird thing, I will say before I get into my take of it, here's the weird part. They don't say they have any eyewitnesses, and presumably they didn't. So how do they know that he watched her bleed out, that he stabbed her and then watched her bleed out? How do they know that?
Because something is not being said. The defense's statement that was released, if you also have that, speaks volumes in the precision of how they skirt their interpretation of the evidence. I believe that a lot of this is supposition, and by the way, which is perfectly fine in a circumstantial evidence case.
But they're stating it as fact.
What? Yeah, they're stating it as fact. Exactly. There's a difference between inferring from the data to stating it as a narrative as if there were eyewitnesses all the way along.
Okay. So can I give you my take on this? I want to see what you think. We haven't talked about this, but when the Rodney King trial happened, I was a reporter at the CBS affiliate in LA. And I covered Rodney King from the day the George Holliday tape surfaced to a year later when the case was tried, and I was at the trial every day. And so they were found, the officers in Simi Valley were all found not guilty. And it was kind of stunning to me at first that when...
Remember who the judge was?
Yeah, now I've forgotten.
Stanley Weisberg.
Stanley Weisberg.
What other trial
Menendez.
He presided over?
Yeah, Menendez. Okay. So I was stunned when that happened until I started thinking about it. And actually, I had watched the trial, so I saw this unfold. But the media, and I will absolutely blame myself, we focused on 13 seconds of a 91-second tape. And the 13 seconds was when they were just beating the crap out of Rodney King. And that's the part we ran, and I ran every single day for a year as we did a lead up to the trial. When the trial happened, the jury saw the stuff that they hadn't seen in the news. They were so convinced it was officers just beating and beating and beating and beating and beating. And then they saw the other parts. And the other parts, frankly, were subtle. But the lawyers for these officers started showing the jury, look at this frame, look at these 2 seconds where the officers back off and Rodney King moves toward them. And it's really subtle. And ordinarily, I don't think it would have made that much of a difference. But they were so used to seeing just nothing but brutality that those subtle things in the remainder of the tape became huge for the jury because all of a sudden they hadn't seen any of that. And the fact that they weren't beating Rodney King for a lot of it, that Rodney King was moving, was so profound for these people that it actually backfired for prosecutors, that all people heard was this damning evidence every day. The reason I'm raising it is I'm reading this brief and I'm thinking, well, is the prosecution doing the same thing here? That they present it like this is an open and shut case. And if the jurors start hearing this and they form an opinion, then all of a sudden, if the defense starts poking holes, even if they ordinarily wouldn't be enough, it's going to get magnified because the prosecutors are saying, look how guilty he is. And if it's more subtle than that, it may really work against them. Is that making sense to you?
Yeah, it does. But my explanation for both Rodney King, the acquittals, and Harlan Braun was one of the 4 lawyers who tried that case out in the Simi Valley. The most critical defense move in that case was their motion for change of venue, which was granted, and they went from downtown LA
To see me,
to
I get it. No, I agree with all of that, but still,
because your jury was receptive to this idea
yeah,
that you can put it in greater
that's right.
context.
I mean, I think
The
that's right.
the difference here is child porn, child porn, child porn. That is a very difficult. But
You know,
I
but you know what the porn might be, and we don't know, but you know what I'm guessing it is?
pictures of her.
Yeah, it's him having sex with Celeste, is what I'm
Yeah,
thinking.
and I'm not so sure, but we'll see.
And by the way, I'm not excusing.
Sure
By the way, I want to suggest I'm excusing that because it's appalling that this 19-year-old is having sex with a 13-year-old. But I'm guessing that's what this is, at least.
And I'm assuming it's him as opposed to you just see
Right,
her.
right. But or maybe it's a combo.
Yeah.
Maybe it's a combo.
And that is, interestingly, they didn't charge possession of child porn. They did charge the continuing sexual abuse of somebody under 14,
Right.
which leads me to believe that they don't have a clear video of on his phone or on a device. But I still think that given the way this preliminary hearing brief was written, that there are a lot of inferences that are being made that they don't have a witness to, and it's more of a closing argument than it is what is an opening statement of what the evidence will produce.
Yeah, it's interesting because when they held the news conference, the DA held the news conference, when they charged him, they talked about data and forensic evidence, but they never said eyewitness evidence, which I thought was really interesting.
And by the way, we have talked repeatedly here on this podcast about the fact that everybody who connected with this from LAPD has told me that there was robust, and that's their term, robust analytics data collection, meaning they had done the triangulation, they had done the cell phones, they had gone and combed through, as we've seen now, Amazon records and other kinds of records. And one of the things that at least initially looks very damning is in the preliminary hearing brief, they're saying that he used the false name. Well, I'm not so sure that doesn't give an opening to the defense as well. Well, there was a name, but how are you saying that it was him and it wasn't one of the hangers on? One of the, better than virtually anybody.
But it's got to be delivered.
Yeah.
Well, if I know, but if it's delivered to his house, I get it. I get it.
Haven't you reported repeatedly on the house and the amount of activity?
There was a lot of activity. There were other people in the house. The house was rented by his manager. And he wasn't, that was never his house. He had stayed at that house, but the manager is the one who actually rented it. And there was a lot of activity. There were a lot of parties. We talked to neighbors who said they were constantly complaining about noise. And they said they'd even call the police, over, these big parties they were having at the house. So, yeah, there were a lot of people. And maybe that is going to be an opening. But I got to ask you about the, having sex with a 13-year-old. If that is true, and there seems to be a lot of smoke there, that if it's true, that would seem like more than just the benefit of the doubt goes to the prosecution.
There is a reason why at that one hearing when the defense was not going to waive time, their speedy trial, speedy preliminary hearing in this case, that it was mentioned not once, twice, but 3 times. That is a enormous hurdle to get over if you're the defense. There is no constituency for child porn, so to speak. And if you've got the videos, and if the videos are of her, and then she ends up as she did, dead, and you've got a inflatable pool, a burn cage, chainsaws, and the parts that are dismembered,
Right.
you better have an explanation for what went on. It's one of those cases where you're not presumed innocent. No matter what the judge instructs, no matter how you want to frame it, the defense is going to have a coherent alternative theory as to what happened. I suspect they're building that, and I suspect they thought initially, and one of the reasons they did not waive time initially and kind of forced the prosecution's hand. And to the prosecution's credit, they came ready. They said, we're ready. And they objected to the continuance of the preliminary hearing. I think that there is more. I still think the way the preliminary hearing brief was framed, it was clearly a narrative. It was clearly argumentative. It was clearly presuming a lot. However, the way it was framed leads me to believe that there is not the damning connection between the evidence and to him. And that's
we'll see.
also
Yeah, we'll
based
see.
on, do you have the statement by the defense? Because the defense issued a statement
they are saying he flat out, he did not kill her. Not
right.
that you can't prove it beyond a reasonable doubt. They're saying he did not kill her. So it's going to come out.
So what do you think about that? Why would you be so bold as to say they can't prove that? I believe that they think that there's a lot of suppositions that are being made that aren't backed up by the data, including, you were getting pretty good leaks in real time over the last 8 months.
Mm-hmm.
I mean, when you take a look at this 9-page screed, there are, it's basically a highlight of the leaks that you've reported on for the last 9 months, 8 months.
Going to Santa Barbara, the remote area of Santa Barbara. We talked about that for months and months. So during this trial, I'm wondering just what the defense is going to do here, because I more than believe you're right, that they are going to challenge the veracity of a lot of the things the prosecution's alleging in this. I'm absolutely no doubt on that. But one of the things that is on the table is having sex with a minor under the age of 14. Correct. And so if they, and then you've got the murder charge. And so if the defense really fights the sex with a girl under the age of 18, and they try and show it wasn't, they didn't, there's no proof that they had sex, and, they just really mount a defense on that issue. If the jury doesn't believe them on that issue, I think that really hurts the defense, because it's sort of like, oh, wait a minute, you're lying to me about the having sex part. He had sex with her. He must have killed her. I mean, I think if they believe the defense is mounting a phony defense on having sex with a girl under the age of 14, they're going to kill him on the murder charge.
Correct. And that my guess is they'll make a motion for a severance to sever that because it's too inflammatory.
With 2 different juries?
Yeah. Well, I don't think it would be 2 different juries. I think they would say, let the sex charges come after, and it's going to be denied because a judge is going to rule that it's and the prosecution.
Well, it's part of the whole case.
Correct. But they're going to make that motion.
But it's not, so that's not going to happen. So
correct. It'll be denied.
It will kill them if they make that argument and they lose.
But if the evidence is such that they cannot defend plausibly, and part of what you do as a defense lawyer, you should do, because I've criticized lawyers who don't do this, you can't lose your credibility with a jury. If you lose your credibility with a jury,
Right.
you've already lost the case. So one of the things they have to do is they have to examine the evidence. If on that phone it becomes apparent from looking at it that there's no plausible way you're going to argue that he didn't have sex or that there wasn't a relationship of some kind, then my guess is you take your lumps and you embrace it and you emphasize the fact that yes, she was underage, but this guy was 19. He was 19, she was 13. It's 6 years. It's not some creepy 35 or 40-year-old with a 13-year-old. I mean, there is that kind of holdover from a bygone days.
Do people buy that?
No, but they do make a, they
What'd you
don't
make it buy?
necessarily buy it, but they do make a distinction. There are people make a distinction when they're, and by the way, the law makes a distinction. If you are within 10 years of the person, that the law recognizes that. That's something that is recognized in the penal code. So it's not idiotic to raise the issue. In fact, in stat rape cases, it's even a more condensed period of time. In
So
fact,
in O.J. Simpson and
yeah,
many murder cases, they tried to dirty up the victim. With Nicole, they said she was doing drugs and that it was a cartel that did it because they owed money and all this. Seems risky, I mean, for them to start saying, well, Celeste was a runaway and she had a messed up family life and, all that. If do they do that? Do they not do that? I mean, I don't know how they handle that.
I think a lot of it depends on the text. Uh, Given her age, given all the issues, there could be an argument. I don't know. I haven't seen the text messages, but there could be an argument that a lot of what was happening there was kind of a lashing out and this or that. I still think that given what the defense is saying, they're being very precise in their language when they're saying that, and they're parsing the language in such a way that leads me to believe that they have an alternate theory as to what happened.
Oh, I
And the
believe that.
alternate,
I believe that's true.
right. And so if they've got an alternate theory, you don't have to fight all the facts. If you've got an alternate theory that makes sense where the evidence points to that, remember the definition of reasonable doubt is two reasonable interpretations. They don't have to be as reasonable. If there is another interpretation that points to the fact that it wasn't him, that it was a hangers on, or that it was somebody on the periphery, or that the death itself was not a killing, but was, as we had talked about before, an overdose. And if they've got a pathologist or a coroner, a medical examiner who under cross-examination or has been hired independently, who will say that, you can build a whole scenario around that as well. You could see that much of what happened was not pre-mortem, but post-mortem.
Yeah, I think one of the things, if it's true, that's going to really hurt the defense is if it's true that after her Uber arrived at David's house, like 20 minutes after, he texts her and says, "Where are you?" If that turns out to be solid, it feels like a cover-up.
I agree. However, what if after the Uber gets to the house, she was intercepted by somebody else? What if there was,
Yeah.
and he's saying, "Where are you?" Because he legitimately doesn't know. And by the way, they will know who was frequenting. One of the things that they know that they have not released yet is they will have records of phones that were present at the exact time that were pinging off of the cell towers. They will be able to trace that. They will know, and they've done, based on everything I've heard, a pretty exhaustive investigation as to who was there then. If in the prosecution's own records, which they have either by subpoena or grand jury subpoena or search warrant have obtained records that show what cell phones were there at the precise time on April 23rd, April 24th, April 25th. There's going to be a circle of people that the defense will investigate. I'm sure the defense already knows or has a pretty good idea that have some connection here that potentially could be an alternate explanation.
So I'm sure you're going to disagree with this. If I were the defense and I were picking a jury, I think an ideal juror is somebody who has heard about this prosecution's brief, who heard it on the news, who read about it, who followed the case, who thinks it's so solid against David, but it's also somebody that you believe could be open-minded, because then they go in with an expectation that the proof is at a level 10, and if it's only if it ends up at a level 7, that might be reasonable doubt for that person. Whereas somebody who's totally ignorant, this may be enough for them. So in a way, I think somebody who kind of, drinks or who believes this, but really can be open-minded and say, look, this is the kind of person I am, and they give an example or examples of how they've changed their mind and all of that. I know that's not the way it's normally done, but I always think that what you never want in a case is for people to have unreasonably high expectations of your case. And to me, that's a bullseye.
I don't disagree with you. I think in a circumstantial evidence case, you want somebody who is intelligent, who is a critical thinker, who is going to be able to examine that. And by the way, one of the other things is the prosecution filing of this brief may be great initially in terms of kind of this smear campaign, if you will, or getting their story out there in order to taint the jury pool. However, a smart defense lawyer is going to hang that document around their neck at trial and is going to say, oh, what about this? I can see the cross-examination with an investigating officer. Who was the witness to this? Who was the witness to that? Where did you come up with this? How do you know that? So did you just put that into a filing? Did you tell this prosecutor over here that that is what happened? How did you base it? Where did you come up with that? Or did you do that just to kind of push back and try to smear my client? I mean, that is the fair game for cross-examination, because if you overstate what you've got in the way that you just earlier mentioned, that's something a competent defense lawyer is going to attack.
Okay. So if you were defending this case, from everything we're hearing, she had a really messed up home life. And it's one of the reasons she was running away all the time. So do you call her parents to the stand and other relatives to kind of create a situation? And I'm not saying this is the right thing to do, but I'm saying lawyers do stuff like this, where they're going to paint her as so desperate that the parents are responsible for getting her in this situation, and they blame the parents as much as anybody else, and that inures kind of to the benefit of David.
So Prosecutor 101 in murder cases is a lot of times to lead off with a family member, to set the stage, to talk about the victim, to make the case about the victim, not about the defendant. And if that is the case, by the way, victim, I always would argue in other contexts, is a legal conclusion. Here, clearly, she is a victim. She was murdered. But if they were to do that, then the defense lawyer is, and that could be a preemptive strike.
But does it work? Does it work?
Sometimes it doesn't. But you can get out if you do a cross-examination that gets to the truth, that gets to what is actually going on, you have to know more about the facts. Let me give you an example. If some of the things that are in the text messages seem to be directed at David or one of David's compatriots or friends or posse, whatever you want to call them, and it looks harsh, and but you don't believe that it was really because of that. It was because there was a desperation in her to leave whatever situation she was enmeshed in. You'll bring that out, and that's perfectly appropriate. Why wouldn't you do that? Just because somebody says something after the fact, meaning a prosecutor says, I've got somebody here, nobody deserves to die. Nobody's fighting that. Of course, nobody deserves to die. Certainly doesn't deserve to die in the fashion that the prosecutor is suggesting. But if part of what the home life was that you had somebody who was difficult and was using drugs, and if they were, I'm not saying she was, but I'm saying if you were, and if the ME's report is inconclusive on the toxicology, which it appears, at least so far, they're still waiting for further results. All of that is fair game if you're going to get at the truth.
Okay, finally, is it smart for the defense to really go in hard during the preliminary hearing on the witnesses? On the one hand, you're able to show weaknesses and figure out, what the weaknesses are for trial. But on the other hand, you're giving your hand away. Do they go in as hard as they would in the trial during the prelim?
Only for the witnesses who potentially could do the most damage. And that's completely a calculation that is done almost always in real time. You can prepare for a witness, from now till New Year's, but the fact is, until that witness gets on the stand, until you hear what the witness says, you have to calibrate what you're doing in terms of a cross-examination. You don't know going in whether that witness is going to give you what you want, what the temperament is, whether the witness is unmoored, moored, or credible or not. All of that is, as we call it, a game day decision, depending on what they say, how they say it, and how they've been prepared.
Got it. Yep. Okay. Well, this is going to be interesting. So the prelim prelim is next month.
I have one question for you. Do they go to the grand jury between now and then?
I don't. I thought about it. It's sounding to me. Look, they could, but I don't think so. My gut tells me no. That they're going to have this prelim. That's my gut.
So,
on the other hand, maybe this weird brief they filed is because they are going to go to the grand jury, and since it's not going to come out during the prelim, they wanted to put it out now. So that's the other side.
It's exactly where I am. So I'm at the latter. I think they go to the grand jury, and then they'll frame it afterwards. The defense was wasting time in delaying this. The victims need closure. We went to the grand jury, and hoping that nobody asked, well, why didn't you do that?
Fascinating. Okay, my friend. I'll see you next week.
Bye-bye.